and I decided we would skip the boring recitations of biographies and panels, because that's always kind of dull. But what I will do is just quickly introduce myself, ask each of our panelists to give you just a brief introduction. Their bios are on the materials. I'm Brad Frazer. I'm a partner at Hawley Troxell here in Boise, and I practice intellectual property law. We have Dave.
Yeah, hi, I'm Dave Smith. I'm the official non-lawyer in this panel. I work for Clearwater Analytics and Technology.
Thank you. And do you go Alexandra?
Alex is great. I'm Alex Hodson. I work at Holland & Hart, and I also work with Nick at the UI Law Clinic, and we do trademark stuff too, if that's of any interest to you guys. And I'm a lawyer, if that wasn't obvious.
And I am David. I am the Assistant Regional Director of the Rocky Mountain USPTO. We're a satellite office, regional office of our headquarters team out in the DC area. We're based out in Denver. And so I'm on the government side. So we got a little bit of everything here.
Yeah. David, Alex, and Dave, thank you for joining us late on a Friday. This is officially like the last session on the last day. So kudos to all of you for struggling through the entire week and joining us at the end of Boise Entrepreneur Week. And we're pleased to see you all here today. Our topic is don't leave money on the table, IP in deal valuation and deal structure. Now that's a mouthful, and you may think, well, holy cow, what's this about? And so let me, if I may, since I'm the moderator, if I may just give a brief introduction to what we're talking about and so kind of set the stage for our panelists. So in my experience, when you do deals, whether you're buying a company or selling a company or going out to get an investment round as an entrepreneur, invariably somebody, the investor, the buyer, the seller, doesn't appropriately evaluate intellectual property, and so money is left on the table. And so we hope that you, as entrepreneurs, will remember to think about from the very inception of your idea to begin to appropriate value in your intellectual property portfolios. Because, as I like to say, when you go to exit, and Jonathan's laughing because he's heard me say this 50 times. Oh, and there's Jonathan Wheatley is my associate at Hawley Troxell. We have Shane Stewart and Kim Kay. They're from Hawley Troxell as well. If you've amassed a significant intellectual property portfolio, when you go to exit or get an investment round, you'll add a zero to the deal, the check, or 2 zeros. And some of you may say, well, that's just not true, but it is true because we've seen it, and these guys up here have seen that as well. So this is what we want to talk about today: intellectual property awareness, situational awareness of intellectual property as you're structuring your companies and as you're thinking about deals and exit and going out to raise money, okay? So at a high level, it occurred to me as I was walking in that none of this introductory material discussed really what intellectual property is. So the panelists will humor me if we just quickly say, so we're talking about today 4 kinds of intellectual property: patents, trademarks, copyrights, and trade secrets. And they all do very different things, and we won't go through that today, but we'd like you to be mindful of the 4 different kinds of intellectual property as you're conceiving an idea, taking it to market, planning an investment round, or anticipating an exit. All 4 of those will be looked at in your portfolio as you anticipate one of those events. So a sophisticated buyer or investor, one of the first things they'll ask you in due diligence is, show me your intellectual property portfolio. And hopefully there won't just be, a gasp and a blank stare. You'll actually have, 50 pages of stuff to show them. So with that, here we go. Here's the canned question I told I would warm everybody up with. In your experience, panelists, have you seen intellectual property play a part in company valuation? Dave, have you bought and sold companies where intellectual property was part of the deal?
Yes, I have.
Okay.
So I've been on the sell side in intellectual property. So a little bit about me. Before I joined Clearwater Analytics, I started at a company called Financial Engines, which was a venture-backed startup in the Bay Area that was doing investment advice and 401k, in the 401k market specifically. And we raised capital through multiple venture rounds, as well as eventually sold the company. We went public and then sold the company to private equity. And so we had a combination of software patents. Then we also had a lot of trade secrets, stuff that we kept confidential just on our algorithms, how we developed our financial advice. And really that's what kept our company competitive in the marketplace. So what our advice and our financial advice that we gave to about 1 million people in the United States, about 200 billion of assets under management, was proprietary. And some of it was protected through, as I said, patents, and some of it was protected through just trade secrets, and we kept that information confidential. But that was what was really valuable and what kept other people from entering into our space and gave us a valuation that was far more on the positive and the negative. So.
Did you add a zero to the check, Dave?
I can't say. I mean, when we sold the company to private equity, it was for $3.4 billion, so that was a pretty good deal.
Two zeros. Okay.
So, but when we raised capital, I mean, we were, as they said, we raised capital from big venture capital firms in the Bay Area, and we raised in November of '99, which was pretty long ago, $85 million, which doesn't sound like a large sum of money back now, but back then that was unicorn level status. So.
Very good. Alex, what do you tell your clients on that question when they say, well, Alex, how important to my valuation is intellectual property? What do you tell your clients?
Yeah, I mean, I'm all about IP. I love IP, so I think it's very valuable, and I've seen it on the good end of before you get acquired, having your ducks in a row and having all of your IP protections in place, and you're solid there. And I've seen it on the bad end when you get into trouble, you're trying to sell your company or get funding, and you don't have any of this stuff going on for you. You don't have your applications on file, you don't have registrations, and that's a cluster. So highly important from my perspective.
And David, you've not always been in the public sector. You've been in the private sector, haven't you? Or if not, that's okay.
I was a ghostwriter for one patent application and then went straight to the government.
So as a government employee working in USPTO, then you see this from the government's perspective. Talk about IP in terms of deal valuation from your perspective, David.
Sure, and most of our regional directors from Detroit, Denver, Dallas, and San Jose had some experience in the private sector. They did M&A, mergers and acquisitions before, and they always talk about the value of what those portfolios look like. We had a white paper called The Right Side of Patents. If you want to look that up, it's very boring because it's a government paper, but it does have statistics and numbers in there that really matter, kind of show how companies are valued, how they increase the first round funding, second round funding, the likelihood that they'll be, bought out or, whatever their goal is. The zero might be multiple zeros if they're coming up as a startup. And with our other government agencies doing SBIR, STTR, that's usually when the government defense teams allocate money for certain companies. They provide funding, and they always look for IP in their quad charts. Just kind of see what your portfolio looks like, where you're going with your company, and kind of gives you a promising outlook essentially. And so there's a lot that plays into that, and that's kind of a broad, high level answer. If you want to look into the statistics, you can find some of that more pointed research.
David, you mentioned the acronym SBIR.
Yep.
Would you tell the audience what that is, please?
So the SBA, SBDC, the Small Business Administration, Small Business Development Centers, they offer government agencies the ability to fund small companies, essentially. It helps kind of the entrepreneurial startups that are trying to do something else, and if it's something that's important to the Air Force, they'll sign a defense contract with that company. They used to do a road tour where they travel the country, host these events in person so that people could have questions to the representatives of all of these agencies. More often these days now, they're housed in the SBDCs themselves. I just talked to Marie over at the SBDC area. And so, if you want to look into government funding as opposed to just the VC funding, then that's one of those avenues.
Thank you. It's important because most entrepreneurs always ask that question, where do I get the money? And David makes a good point about SBIR. It's one that's, for whatever reason, oftentimes overlooked. So keep that acronym in mind when you're looking for money. So our first question was, what is your experience relative to IP as being part of deal valuation? But for the second question, we flipped that on its head. Conversely, have you seen cases where parties left money on the table because they weren't cognizant of IP? So I'll tell you my story, and then I'll ask the panelists if they can comment. So probably, let's see, now it would have been about 14 years ago, I was doing a deal for a client. We were buying a software company. It was a $20 million deal, so not huge, but $20 million to buy a software company. So we're on the phone with their lawyers in Chicago, and I'm over there in Boise, Idaho, 10th floor, just over there. And I innocently asked the Chicago lawyers, because we were doing due diligence right on their IP. I said, you're a software company, tell me about your copyrights. And they said, without any sort of guile at all, they said, well, we don't have any. Now, those of you who know how striking that response is for a software company to say they don't have any copyrights, and I just paused and I looked at my partner and we kind of laughed. Well, of course they have copyrights. Of course, they're a software company. That's all they have to sell. That's all they have to sell is copyrights. How many books does Amazon own, sir? How many cars does Uber own, sir? How many houses does Airbnb own, sir? 0. It's all intellectual property, right? And if you're not properly evaluating that, you're leaving money on the table. So I looked at my client, I muted the phone, I looked at my client and said, take a 0 off the check, because they don't have any IP. Ma'am, have I offended you already? I so apologize.
I'm so sorry. Have a great day.
Okay. Yeah. So we want to always be cognizant of IP and deal valuation. So that was my example of money having been left on the table. Panelists, any examples like that? And if not, that's okay. Have you seen situations where your clients or others didn't appropriately evaluate IP and money was left on the table?
Okay. Yes,
I'll let the real lawyers talk about this
Yeah.
one. Yeah.
Okay, I have a couple of responses to that. Yes, I currently have a client who's scaling up right now, and they don't really know what they have for IP, and we're trying to help them build their portfolio up so that they can get acquired or go IPO at some time. But they're at the level where they actually don't know that they have copyright, software stuff going on too. I've also seen situations where people are trying, or companies are trying to get acquired, and they get in trouble with having infringement lawsuits hit them because they're stealing IP or they didn't do their due diligence or something, and that can hold up their deals, unfortunately, and also take a 0 off their check because litigation is incredibly expensive. So.
Right. Good, thank you, Alex. Dave or David, any other observations where you were in a deal and maybe somebody didn't think about IP and it affected the deal value?
Not in the deal process, but shortly after we did do a transaction, we were hit with litigation around a patent law.
Okay.
And fought it and won.
Good.
Related to kind of, someone that had claimed that we had been doing patent infringement on their patents, and we actually established that we had patented, we had the IP, we own the rights to it. I don't have all the specifics because I wasn't the lawyer involved, but I do know that we got sued and we won.
Good for you.
So,
well, those are good examples, team. Thank you for suggesting, and we would just invite the audience to remember that we know that there are cases in which you add a 0 to the check when you've appropriately evaluated your intellectual property. We know there are cases when 0 comes off the check if you hadn't, or even worse, post-close, because you didn't think about IP, you're going to get sued. Just as Dave mentioned, it's just hypothetical.
Brad, can I interject also and just think about the labor cost that's involved in not having the whole portfolio in front of you. My boss, Molly, worked for 2 Fortune 200 companies, and anecdotally, she's gotten involved into some acquisitions where people didn't know what IP they had. And so, whenever the lawyers have to do the research and be like, what is the 75 other trademarks and copyrights and patents that you have going on here? And the company's like, oh yeah, those things. That significantly burdens the rest of the team as to how much they got to spend and work on trying to clean that out. When a company has to be split, that's going to cost the people some money there somewhere because somebody's got to own this IP one way or another, and just the laborious reasons for some of that stuff is a major deal.
Thank you. Okay, so I'll ask each of you in turn in different contexts. So Dave, you're the CEO of a new startup. When you leave Clearwater, you're CEO of a brand new startup. Okay, you've got 2 employees. Alex, you have a brand new client just sending you an email. David, you have some guy in Des Moines, Iowa sending you an email, and the question is, for each of you, how do you help, in that context, how do you help your new company, Alex, your client, David, this citizen, how do you help them identify their IP? I mean, they say to you, the email effectively says, I hear about intellectual property, but how do I begin to understand what it is, assemble it, and evaluate it? You're the CEO, Dave, what do you tell your team?
So in the context of the company that we've started,
Yeah, sure.
So I think it's when you're starting a company and you have an idea, and I come from the software and technology side, that is the IP. The company is the IP. Without it, you have no value in my perspective. And so really, it's really important early on having good counsel, and really establishing, and as we were talking about before, like what is it that differentiates your company from someone else in the marketplace? I believe, at least when you're trying to raise capital, if you go to like venture capital especially, they're going to look for you, they're going to look at the team, that's obviously important, but they're really going to look at the idea, and can the idea be easily copied? And are there protections in place that prevent that, whether that it's technologically very complicated, it's protected by patent, or some other case whatsoever. So that from my perspective, that's where it's just, as you're getting going from a software industry perspective, it is what the company is.
Start with the idea, and then begin to sort of build protections around that core idea. Very good. Alex, what do you tell that client when they email you and say, Alex, how do I get my arms around starting an IP portfolio?
Yeah, gosh, that's a conversation. So, my first question would be, what industry are you in? Do you already have a trademark picked out? Do you already have any like patentable or trade secret stuff going on? So I try to like suss out what they have going on if they don't already know what they have going on themselves. And then, you know, I would go through trade secret. Here's a trade secret, here's a trademark, here's a copyright, here's a patent. They're all different. Sometimes they overlap. So I guess the conversation would just be starting with the basics and figuring out what they're doing and how we can help them.
It's sort of an academic approach, right? Like, let's just go through the kinds of intellectual property and see what you've got. It's a
Right.
great way to start. And David, what do you tell our hypothetical citizen from Des Moines when they email USPTO and go, I want to get a patent, how do I do it? What do you say to folks like that?
And more often than not, I hear I want to get a patent on this logo, right?
Yeah.
There's the confusion of
Sure.
what the different forms of IP is a really big thing, and so as we do outreach on behalf of the agency, that's kind of the major thing, is to stress that there's these distinct forms of intellectual property. This is what a trademark is. You know, whenever you think Robin Blue Box at a jewelry company, most people think Tiffany. Delivery trucks, you know, you go see a brown truck pull up to your house, you're going to associate that with UPS, right? So you make it relatable, kind of explain to them the different reasons as to what a trademark is. That's designating that brand, you know, kind of ties it back into them and makes it a little bit more personal. You know, if it's a garage inventor and they're trying to put these ideas out, then you can talk to them about, well, this is what a patent protects, you know, your widget, your method of producing X, Y, Z, or whatever it is. And then, you know, you kind of say, you don't, well, from my side, this might not be popular to the agency in general, but you don't necessarily always need to pay for certain IP. Whether it becomes a patent or a trademark, or you keep it as a copyright, there's different forms of protection, and it's not a one-stop shop. It's not good for everybody. There's not a certain template. If you're trying to protect the color of a football field, you go to Brad. He's a guy that's done something like that, maybe, you know? So lawyers are going to be needed for certain trade dress or trademarks, and you know, patent attorneys are getting paid for a reason, but you have to have the end in mind as to what your business goal is. You start with the idea, like Dave said, and then you go, what's your end goal here? And then we'll work from there and try to fill the gaps with someone like Alex.
That's very good, David, thank you. So my takeaway is, the moment you have that idea, as Dave said, begin to coalesce intellectual property around it. Go to uspto.gov, check with Alex, talk to David, and begin to build proactively your intellectual property, even from the idea inception. There's no point at which it's too early to begin to think about intellectual property, and far, far better to think about it pre-launch and at idea inception, rather than waiting until after launch, and like Dave said, you get sued, or you know, something bad like that happens. Okay.
So I would just like to add on a little bit about that. And you know, from an engineering perspective, having good documentation and having good records is super critical, because that's when you've ideated, you've documented, you've dated, signed it. Like, there's books. I actually still use to this day a book that is designed for patentable ideas that has like the date and then you sign it. You know, I'd like it be more because I like the graph paper and I'm an engineer and I get down on that. But seriously, documentation. You know, I've been in these situations where it's like having that documentation, having those artifacts cataloged, organized, and around is super important. Versus if you think you had the idea, but someone else has proof that they had the idea sooner than you did, or before you did. I mean, it's a very different thing. So.
Very good, Dave. Jillian.
On that note, what if they had like an idea but didn't elaborate, and yours has a component that they don't have, like a part to a system that they did not disclose? Is that still patentable?
It depends. Great lawyer answer, right? I did go to law school, so I can't say that. But the fact is, it really just not most of the inventions that are patented are not brand new ideas. There's some kind of iteration or innovation that, you know, is off of something else that is already existing. And so the patent examiner is going to look at the application and say, is this enough, basically? There's a couple of statutory hurdles that you have to go over. And so basically, you know, you just have to go meet certain rules. But the examiner's job is to find out whether, you know, Alex and Dave would think that together that idea should have been out there already. That's their whole job. And so I know, terrible answer, but that's really just the bottom line there.
Okay.
I see.
So if you're building a technology that you think is uniquely complex, what is the cost, like the exploratory cost associated with evaluating that technology to see if it is patentable?
Oh,
Wow.
do you mind if I take this one?
Go for it.
And then everybody else can jump in. Okay.
Especially because you say before, you build a business, it's an idea, but at that point of the startup, you're really looking at costs when you're self-funding.
Yeah, and I hear all the time that startups don't think about IP because it's too expensive, and that nobody cares about IP for that reason.
Right.
And gosh, I invite you to call me, and we'll spend an hour on the phone for free, or call Alex, or call somebody on the panel, and we'll tell you why that idea is really wrong. I mean, it's wrong. You can get a very, very robust foundational IP portfolio in place that will satisfy any investor or any buyer or any exit for less than, are you ready? $5,000. How about that? You were thinking I was going to say $100,000, but it's not. It's just not that involved or complex. I mean, it's just not. You file a couple of copyright registration applications. You file an intent to use trademark registration application. You go get 20 domain names, right? You go get free social media platforms, and you file what's called a provisional patent application. If you're a single inventor, you can do that for, guess how much? $85. Where's all the money going? Why is it so hard to amass an IP portfolio for a startup? I don't understand it. So you're getting sold a bill of goods when somebody says IP costs $50,000, $100,000. It's just not true. So you can see how strongly I feel about that, because people get bad advice on that all the time because it's just not true, right? So even from idea inception, so you come up with an idea, right? And you file, let's hypothetically say, okay, you file one provisional utility patent application, $100. You file an intent to use trademark registration application, $250. You doing the math? You adding this up? Copyright registration application, $65. 20 domain names, $160. Social media, free. Couple of good contracts, $100 if you get them from a good lawyer. Anybody add that up? What is that? That's not even $2,000.
It's under a grand.
Yeah, it's under grand.
Right. So Nick, somebody tell me, what am I missing here? That's all true. I mean, I know because I've done it. Alex, you've done it.
Yeah, I've done it.
You know?
Somebody do all that for me for a grand?
Well, no, I can't file a provisional patent application for you because that's your filing fee as the inventor. If you hire a lawyer, it's a little bit more expensive. But we won't go into the weeds of provisional patent applications, but you see the point? So people get spun around the axle about the cost, and it's just not that expensive. It's just not. Okay, let me talk to you real quick, and then I'll turn back to the panel because I'm doing what I always do. Don't do any patent searching on your own. Hear me? Don't do any patent searching on your own, any of you. Who can give me the two, Alex, anybody give me the 2 good reasons why? David, why don't you do any patent searching on your own? Dave, Alex? Do you know?
Well, it's dangerous because if you come upon something that you might be willfully infringing if you know about it and you keep going.
Right, thank you, Alex. The reason you don't do patent searching on your own is, one, anything you find, you have to disclose to the patent office when you file a patent application as prior art. So you're a subject matter expert and you might invalidate your own patent because you have to disclose it. Why would you do that? The second reason you don't do any patent searching, unless you hire an attorney like Alex or somebody to do it, is if you get caught and sued for patent infringement, they're going to depose you. And they're going to say, isn't it true, sir, that you knew about our patent because here's your browser history, and here's your server log, and here's your IP address, pinging the USPTO on this date, and here's your browser history that shows you looked at our patent. Did you, sir, at that point get a non-infringement opinion of counsel? No, you're a willful patent infringer. That means that the damages they went against you are tripled because you're a willful infringer. So don't do any patent searching. There's just no upside unless you hire an attorney and do it under the attorney-client privilege.
Brad, can I add a little stuff to
Please,
this
yeah.
conversation? While we're on this topic, the pro bono program, it's out of the University of Idaho Law. You can talk to Nick. Somebody else. Trademark Clinic, those are all means as to how you get free legal work. There's some parameters that are involved. It does make a difference. There's cost mitigation things if you are a sole inventor, if you have a small company, we call it microentity status. Gives you a 75% reduction in patent fees. Not so much on the trademark side of the house because it's really cheap already to do trademarks. The system sucks for the trademark searching, so I mean, if you're trying to see if your logo is out there or your brand is out there, it's really hard, but it works. The public search that's available now for patents and stuff, it's a little confusing, so it makes it a little bit more difficult, but it allows you to kind of see what's out there. So you can do a little bit of background work. I
Is that like
let
the test?
Brad
The
talk about
TES
that.
test is?
Yeah, test, yeah. So there's a couple of ways that you can mitigate certain costs for the legal fee side of things, but that's why they get paid so much, because they're the experts. And that's why I'm on the government side, because I'm never going to be as good as these two whenever it comes to that stuff.
So Elon Musk just paid $44 billion for Twitter. Twitter doesn't have patents. So what's worth $44 billion there?
Data.
David says data. What else is, why is Twitter worth $44 billion? I agree with data. Why else?
Adoption.
Good.
Advertising.
Okay.
Audience.
So
Assume that's data.
data, right, good.
Audience.
Are you asking like for like intellectual property? Are you saying like the trademark essentially?
That's exactly what I'm asking. Why did Elon Musk think Twitter was worth 44, besides the fact he wanted access to that platform, I get that. But what are the legal reasons why it was worth, somebody told him it was worth $44 billion, right? Somebody did an evaluation. Part of that presumably was IP. But I bet it wasn't patents, and I bet it wasn't copyrights, because they're not a
Trade
movie
secrets,
company.
right.
So what was it? Alex, what was it?
I would say the brand.
Imagine that, a trademark worth $44 billion. I think that's right, Alex. I think that's exactly right. So you see that these things that we maybe don't think about intuitively or obviously do have value later in the game. When they founded Twitter, do you think that they would have thought that brand would have been worth $44 billion? Doubtful. Anybody know what the Apple trademark is worth today? Just the brand. They have a lot of patents, right? Their patent portfolio is probably worth, I don't know, well, their market cap, what's $1 trillion? So some of that's patents. But what do you think the Apple trademark alone is worth? 300 billion, just in the brand, right? So Elon got a deal getting Twitter for 44, the Apple brand's worth. Okay, so in the real world, I'm live in this ivory tower. So in the real world, how important is this really, Dave? I mean, and I appreciate you being a good soldier and saying IP is important, but is it really in the real world?
You know, I think it is, and the reason why is if you think about it, you know, IP, whether you protect it or not. So if you think about it, you have intellectual property that you could choose not to protect, and then someone theoretically could do something with it. But you know, from a business perspective, that's what the bread and butter is for the startup in my mind. And so it's up to you to figure out the right way to protect it and give yourself, you know, that capability, because when you go to raise money or sell it, that's what the investor is going to care about. I mean, the investor is going to first look at you and do an evaluation and say, can someone else just take this idea and run with it? If we take it to market, can someone just copy it? And are the protections in place? So from that perspective, you know, that's kind of how I feel about it.
And Alex, let me ask you, in your experience, you're talking to clients and they resist your efforts to help them build an IP portfolio because of all the incorrect information out there. How do you dispel that? How do you say to them, no, pause for a minute, IP really is important? What do you say to your clients?
Yeah, I just break it down to what IP gets you, and that's actually a lot of power. So if you have a trademark and you have a logo, you can get a trademark registration and a copyright registration, and now you have dual protection on your logo alone, and if someone else tries to use it, you can slap them with infringement lawsuits for both copyright and trademark infringement. So it's a very powerful tool, and companies who resist it, I think just need a little bit more education.
Thank you. David, your response to that. People say, you work for the patent office. What's up with that? There's no real value in that in the real world. They'll say to you, David, I had an uncle who got a patent through InventHelp, and he got a patent, and he never made any money. He spent $3,000 with InventHelp getting a patent, but it was hung on his wall in his den, and he never made any money off of it. What's your response to that, David?
I mean, if you can get $3,000 patent, that's a bargain, first of all. So go for that for sure, because I think the average cost of a patent is around $25,000, $30,000 roughly. So $3,000 is a great bargain. But there's a reason. You know, anybody a programmer, software developer, something like that. Okay, great. This is going to be really easy to bash them then. No, I'm just joking. But there's a side of the house that, you know, the open source side of people that thinks that you should not have this going on. What do you think Elon's done with Tesla's patents?
Open source.
It's all open source, but he opens it up to the public. But he patented that stuff because if things go out of control, he can limit the abuses that are done with some of those technologies. And the same thing as Google was anti-patent for the longest time. I'm going to pick on them because one of the biggest things is a trade secret. Their search algorithm is a giant trade secret. No one knows how they do that, but it's been the most effective thing that's kind of changed that company, right? Why did they file patents? Because they did it in an offensive or defensive manner so that whenever they realize that people may be abusing XYZ, they can say, no, can't do that. We own the patent for that. So while we don't care about the patents, that, specifically for this reason, offensively to make money, they are going to prevent people from doing the same things. And so as you think about, IP in general, don't think about it just one-sided as to it's just the cost. There's a cost-benefit analysis in business in general, but it's not always just cut and dry, black and white.
Thank you. Who watches Shark Tank like me? I've been watching Shark Tank for, 10 years? 10 years ago, when people came out, the sharks never said, do you have patents, do you have IP? They never asked. Now, what's the question Lori always asks? Do you have a patent? And they go, yes, it's patent pending, I have an issued design patent. So somebody's getting the vision, right? I mean, people on Shark Tank are getting the vision that the sharks are going to ask about IP. And I think the panelists agree that there's value in IP. The one word I heard here as the panelists were responding is this notion of control. And it really is true. That's the whole point of having a portfolio. Because if you, sir, were going to buy a company, would you rather buy something that has an asset that's completely subject to someone's stealing it with impunity? Or would you rather, this is really a stupid rhetorical question, or would you rather buy a lawful monopoly? Which would you rather buy? A lawful monopoly that permits you to be the only one in America that can do this thing, or something which everybody can do, an open source mentality? Right, rhetorical question. You'd rather have a lawful monopoly, presumably, right? And that's the philosophy of control. IP allows you to create a lawful monopoly and sell it or gain investment dollars. Okay, but now the elephant in the room, you and I went at it just a moment ago on this topic because I feel so strongly about it, but now we're really gonna talk about it. So panelists, there's this tension between all of our entrepreneurs who say, don't need IP, it's too expensive, nobody gives it any value, but you've all said that it does create value. So let's just talk about that. We all believe, you and I discussed this notion of it's too expensive to create a portfolio. How many of you have resisted putting an IP portfolio together because it's too expensive? And I appreciate your honesty, right? It's just too expensive. But the panel and I would encourage you to think, you will get that money back. You'll get an ROI on that IP investment. We've all indicated that that's true. So the key will be to work with people like David and Alex and Dave and me and others to find a cost-effective way to assemble kind of a MVP, minimum viable product IP portfolio. And it can be done. It can be done and it's not very expensive. Enough to satisfy due diligence for that first round. Isn't that the key?
Would you defer your costs until a successful round of financing?
Sure. I mean, there's hardly any work to it. So sure, I mean, I don't mean to be flippant, but I just get so frustrated because people get this notion that it's too hard and too expensive, and it's not,
Yeah, I mean, can I add
Yeah.
something? So my mom started a company where she made a deer repellent. So she had kind of invented this product, and it was kind of a secret ingredient type stuff.
Yeah.
But one of the things I really encouraged her to do is just seek counsel. Go and go find an attorney that you trust, that you know is reputable, that's not going to take you, and get advice, because oftentimes, and they did. They said, oh, you could just do these few things for a little bit of money, and then you're covered. And then as you scale the business, you can start investing more and more and more. So it's like setting up the right first steps. And so she made a couple $100, and did some, got the right kind of language in place and filed a trademark application on her own behalf and did a few things. And so, but my point is just kind of bringing this story up because she was doing a few $1,000s. I think she got up to about $20,000 a year in revenue. So nothing major that she wanted to do a huge investment, but it was a little side small business. But she definitely wanted to keep the rights to her formula and not have someone reverse engineer it because it worked really well. And so I think it's just that seeking advice is what I encourage you to do. Instead of trying to argue whether it's a good idea or not, go find somebody you trust and get their opinion and get their help.
It's true. I mean, at a minimum, let's assume you scrape together a $500 legal budget. Okay, here's what you do with $500. You file an intent to use trademark registration application. You file one copyright registration on your source code. You could get a few domain names, and you get somewhere a really good NDA. And the beautiful secret of NDAs is that if they're done correctly, they're a poor man's patent. Because even if you file a patent application today, sir, how long does it take to get one? 3 years. 3 years. And are the patents effective until they issue? No. Do you have any protection until the patent issues? No. It's all smoke and mirrors. So what do you do for that 3-year period while you're waiting for your patent to issue? The A students, like Nick Smith will say, use an NDA. Because an NDA gives you a poor man's well, you were about to say that.
On demand, yeah.
An NDA, if done correctly, think about it, it gives you a poor man's patent. right? If it's written correctly, it says, not only will you not disclose this thing I'm giving you under NDA, but you won't use it, or make it, or sell it. That's the patent language, right? That should be in every NDA that you give out. Because now, guys, you've got this poor man's patent. That's effectively free. So how much have we spent? Have we spent our $500 yet? You see? So there's no reason to assemble at least a bare bones IP portfolio for a few $100. Okay, David, how does the USPTO help inventors? Do you help inventors monetize their IP? Is there a program to move it into, to make money out of it? And maybe the answer may be no. I actually don't know.
That's the problem with the USPTO, that a lot of people think that we should be on the approval side and the enforcement side and kind of the guidance side, but we strictly only look at the applications and say yes or no, and that's because there's going to be conflict of interest otherwise. Real quick before I forget though, I'm probably gonna get fired for this, but there are pilot programs in place, both in the past and in the future that help inventors. And so I'm trying to say this in a way that I'm not gonna get in too much trouble, but keep your eye out if you're a first-time filer. That's going to be some of those things that are out there. Currently, there's a climate change mitigation pilot, which means if you are filing a patent application that is in a certain class that mitigates climate change, you get priority in terms of examination process. Instead of waiting the 3 years, that maybe sometimes longer. I've had some patent applications that took 10 years or something like that when I was examining patents. But that value though, in those 10 years that you were doing something else, you were filing the NDA, you were looking at the copyrights, you were working on your business strategy. You're going to capitalize on that, and that's when you go Shark Tank. That's when, right, because you have that patent pending. You can say patent pending, and there's a reason why you can maybe not monopolize, but you can capitalize on your business decision of going for that patent application.
Thank you. Alex, so a client comes to you and they've already assembled a bit of an IP portfolio, okay? They've done some good work. What do you tell them in terms of how do you monetize that portfolio? And it's great to have it as an academic construct, but how do you turn it into money, Alex? What do you tell your clients about that?
Yeah, I guess it depends on what their goals are. If they're trying to license their IP, that's certainly an avenue for monetizing, trademarks or patents or whatever they've got.
Just to make sure, talk more about licensing. What is licensing a patent? What is licensing a trademark? What does that mean?
So you can have a non-exclusive license. If you were to license from someone else, they could give you a non-exclusive license, meaning that they can license it to someone else too. That would just be the right to use whatever they have the protection on.
And what do you get out of that, Alex? If you're the licensor, what do you get?
Oh, well, you can use their goodwill and their brand. Or
no, the licensor. If you're the licensor,
money.
What do you get out of the deal? Cash money.
Yes,
right?
license your stuff for money.
Yeah.
Yes, that's what you get out of it.
Right.
And more brand recognition because you have people in different places using your brand.
Right. Have you done any licensing deals, Dave, historically? Have you?
Yeah, so I don't know whether you would consider this a licensing deal or not, but we've done like white label type deals. So as an example, Financial Engines powered all of Vanguard's asset management and investment advice business for their 401ks, but it was Vanguard branded. Vanguard looks like a Vanguard experience, but in the little quarter, it's powered by Financial Engines. Clearwater also does deals where they do a white label deal, so a big financial institution would use buy our product and then resell it. And so it looks like it's their brand's product, but then powered on the channel. So
there's huge power in licensing. I was an in-house attorney at Micron Electronics. That was the one out in Nampa. Some of you may remember, by the Sugar Bee Factory, famously, that made us old personal computers. Any Micron alums here? Micron Electronics alums? And I don't have my glasses on, so forgive me if I don't recognize you. Okay.
No problem.
So the power of licensing. So every quarter we paid Microsoft. We paid them copyright licensing fees for their software, because software is copyright, right? And we paid them trademark licensing fees to put the little Microsoft Windows sticker on every box. Guess how much we paid them every quarter? And we sold, $20-30 million a quarter, or boxes a quarter. Guess how much money we paid Microsoft every quarter just for licensing? $300-400 million. That's just us, little old Nampa, Idaho. And anybody remember DVD-ROMs? Computers used to be sold with this thing called a DVD-ROM that you put a thing in, a little plastic thing called a DVD, and you'd watch movies on it. Well, there was this organization called the DVD Consortium, and they own the patents on what's called DVD Content Scramble System. And we paid those guys, probably $15 million a quarter in patent licensing fees. See what I mean? And the beauty of it is, to have a patent and license it, like Alex said, you don't have to make or sell a single thing. We all have clients who do nothing but get patents and then sit back and clip coupons, as we used to say. You don't have to make or sell a single thing to have a patent. All you have to do is be able to write down in words sufficient detail that somebody sufficiently skilled in the art, like an engineer, can build one of your things. And if that thing is new, useful, and non-obvious, you get a patent. And then you sit back and watch the royalties roll in, right? Everybody thinks I gotta have a prototype, gotta have a prototype. No, you don't. Just have to be able to write it down and describe it in sufficient detail that somebody can build one, right? So I don't want to lose this notion of monetization. As Alex and Dave have said, the key ways you monetize your IP is through licensing, and that means you let somebody else use it and they pay you money for the privilege. The other way, what's the other way we monetize our IP? Licensing is, of course, one way. You've all experienced it. What's the other way we monetize our IP? We sell a company.
Exit.
Exit strategy.
Yeah.
Talk to me about that. I'll start with David. In experience, have you seen people successfully have an exit strategy with a patent portfolio or other IP portfolios? Do you know? I mean, we can look at the news and find one, but do you have any experience with some?
I mean, there are tons of examples. You guys, if you follow certain brands or certain companies, you're going to see that yourself. In terms of the protection side of things, and we'll kind of go what happens before you get to the licensing part, or the kind of the deals that you get involved in that. But on a smaller kind of scale, takedown notices or takedown procedures on the e-commerce platforms, you need some of these to have an actual trademark before you can go and say, Amazon, please take down that counterfeit, right? Those are ways that you capitalize on those kind of markets there in terms of people selling your fraudulent products. Pop sockets, you go from design patent to a trade dress registration, so you go from 15-year protection to infinite protection as long as you're using it. Stuff like that, I mean, those are all things to consider. So whenever you sell a company, those are, if you have a trademark from a design patent, imagine if Dr. Pepper got the Coca-Cola bottle shape at some point. I mean, that'd be crazy. Or the formula, or the trade secret formula that Coca-Cola has. I'm sure that's what, Coca-Cola, I think, spends the most in terms of advertising of any company in the world, I believe, if that's what I've heard. Do you think they need to do that? Nope. But their brand recognition, their brand value would be so high if they ever did sell that Elon wouldn't have enough money to buy them.
Not today, maybe.
Maybe not today, you're right.
Just wrote a check for $44 billion on Twitter.
Isn't the Coca-Cola red like known by pretty much every person on the planet?
Right.
Like that color red.
Yeah, you're absolutely right. Alex, okay, so we've talked about licensing. Have you seen clients monetize their IP through an exit or an investment? Either a round or an exit. Have you seen that occur?
I've seen it more on the side where they're purchasing.
Okay.
So, and that, like I think David mentioned earlier, if you have to get lawyers involved to do your due diligence and figure out, what IP you have and what you've protected, it's so expensive, and we love that, but you guys won't love that. But yeah, having your ducks in a row is just good practice.
So we monetize our IP by licensing, by exit, by getting an investment. Dave, in your experience, what are some of the things you've seen that have resulted in monetization of IP? Licensing, selling a company, any other things come to your mind?
I mean, those are the two big ones. Yeah. I mean, I think in exiting, going back to the point that Alex made, having everything well organized in the due diligence process makes everything go so much faster. And when concerns come up, in the due diligence process in the sales cycle, the buyer tends to, if there is gaps or issues, then they start knocking down the value because they're taking on more risk in that situation.
That's exactly right.
And so it's like, it basically becomes like, I don't know if the asset that I thought I was buying is worth as much as I thought it was, because now I'm not as confident that you actually own the rights to it or own all of the rights.
Very good.
I have a pretty local example for y'all out here right now is this pending deal with Albertsons and Kroger.
Oh, right.
I mean, that's...
The lawyers are...
That's going to be a fun one.
Is your firm working on that deal, Alex? You represent one or both of those guys, don't you? Maybe you can't say.
That says it all right there.
I got it. Well said, well said. She speaks volumes by her silence. So, Jonathan, yeah.
So then what can you do to make sure that you actually own the IP? How do you get it all in one place?
Did you hear Jonathan Wheeler's question? I paid him $5 to ask that question. Well done, Jonathan Wheeler. Well, you're right. The CEO from the very beginning needs to be cognizant of that and make sure the entity that you have formed owns the IP. For example, let's assume you have a startup and it's a web business. It's a SaaS platform. Okay, you've got a domain name, right? wonkytshirts.net, whatever, okay. And it's a SaaS platform where you can go and log in, design your own t-shirt, hit print, a Shopify thing sends you a t-shirt, Yahoo, okay. So, and you get wonkytshirts.net. So when I'm doing due diligence on your company, first thing I'm going to go do is get a who is, and I'm going to see who's the registrant of that domain name. And if it's not you, I take a 0 off the check. And if it's your intern who did your web development and who registered the domain name because you yelled at him and said, go register that domain name without owning it, I'm going to take a 0 off the check. And then I'm going to ask you, sir, when your software company, I'm doing due diligence, I say, prove to me that you own the copyright in your source code. And you're going to say, oh gosh, my brother-in-law wrote the source code. Oh, and I paid him for it, so I own it, right? No, wrong. And so on and so on and so on. So the ways you can not own your IP are just crazy. All right, so we have just a few minutes left, so now we're gonna actually do an exercise. So we're going to invent and monetize a better mousetrap, okay? So that group over there with David, you're gonna think of innovations that you can patent. Innovations that you can patent to create a better mousetrap, because we're now the CEOs of a mousetrap company, okay? And maybe some of you want to go over to join the patent group. But David, you're going to consult with them and you're going to think of 3 innovations that you can patent. We're just going to take 5 minutes and do this. We have time, right? 4:15, right? We're good. Okay. So let's, David, do you mind doing that? Just helping them think of 3 innovations that they can get a patent on. Okay. Alex, would you work with this middle group here and think of a protectable trademark? Please?
Yeah.
Dave, you and I are going to work with this group and we're going to work on copyrights and trade secrets.
Okay.
For our mousetrap startup, okay? So you've got 5 minutes, ready? Okay, patents, trademarks, Alex, Dave and I, trade secrets and copyrights.
Okay.
Go. Okay.
I get the lawyers.
Not expecting
Okay, so I guess I'll.
Hey, lawyer. Okay, guys.
Oh, okay. I get another.
So,
Don't ask me to come on this.
okay, now, good job, David, Alex, Dave, the mentors. Good job, everybody.
I don't know if I was a mentor.
So that took us 7 minutes. What did we actually just do in 7 minutes? This group. What did we do?
Creative.
IP portfolio.
How hard was that? How much money did we spend? And yet, for a little bit of money, we could literally take everything you guys just all came up with and have an idea that we can go sell or monetize or license. How hard was that? Right? Not hard. Okay, patent team. Did you appoint a spokesman, David, or is it going to be you?
No, I'm gonna make Nick.
Nick Smith, do you want to do this first? Give me a couple of innovations that you came up with that we're going to file patent applications on for our mousetrap.
Yeah, so we have a time release live trap. So after you trap the mouse and you go let it go, there's this time release thing, so you don't have to be there when it ethically escapes.
I love that
I
idea.
have a heart. It's like I have a heart.
Have a heart.
Time release.
Have a heart. Maybe that's the trademark Alex came up with. That. Okay, so that's patentable subject matter, probably. We file a patent application on it, it's patent pending, and now we go to market, or we go to a trade show, or we go seek around with a patent pending invention. Yay, good job, patent team. Anything else from our patent team? Okay. Trademark team, what are we going to call our new mousetrap? Spokesman?
Thwack.
Whack.
Thwack.
It doesn't quite fit with the product now that we
Someone
know.
spell that. Spell it.
Is this the opposite of an ethical mousetrap now?
It's ironic.
I love that. Whack. And Alex told you why that's such a great trademark, right? Because you can't have trademarks in something which is descriptive, like mouse be gone or death to mice or rodent killer. Those aren't trademarks, and Alex told you that. Whack is good. Good job, Alex. Why is that such a
Thank
good
you.
trademark?
It's distinctive. And, well, yeah, people aren't going to know exactly what the product is just by seeing the mark.
Did you hear that? People aren't going to know what the product is by seeing the mark, and you're thinking that's counterintuitive. But Alex, that's the exact definition of a strong trademark. People don't know what it is when they see the mark. Even though that's counterintuitive, that's the definition of a great trademark. Good job, Alex. I actually did this exact same hypothetical with a group the other night, and I have to tell you this. One of the guys came up with this for the new trademark. Are you ready? It's kind of brilliant. Alley cat. How's that for a trademark for a new mousetrap? I mean, that's kind of brilliant. I like whack too. Okay. All right. We have trade secret and copyright team. Go ahead, spokesman for trade secret and copyright. Tell them about the invention first. What's our new mousetrap? What are the trade secrets and what are our copyrights?
So the new mousetrap called Whack, I guess.
Yeah. Right. Good. And it's going to have that functionality included. That's fine. We're going to build it right into the firmware. Right. Go ahead.
So the firmware is black box with the mousetrap. So there's trade secrets that we have filed for IP of this.
And how does it work? How does our mousetrap work?
What uses LiDAR.
What does it do though? It's on wheels and it chases the mouse
Yeah,
around.
so it's, our idea is it's a miniature robot mouse hunter, so instead of just deciding to come to the trap goes to the mouse.
Trap goes to the mouse. There's our tagline. Whack. The
Whack.
Whack. The whack.
Whack.
Somebody just spell it for me.
Whack.
THWACK.
Whack. Okay. Whack.
Even more unique, see?
So here's our mark. Here's our. Okay, you're not done yet. So here's our website. Introducing Thwack, patent pending mousetrap. It takes the trap to the mouse. Tagline. Thwack is our trademark. Patent pending. Okay, we've got our trade secret black box right here on our mousetrap with 4 wheels chasing the mouse around because it's using LiDAR. Right? Brilliant. That's brilliant. Okay, what's inside that black box?
A Raspberry Pi.
I like that. Why not? But more to our discussion. What's inside the black box? Firmware with
Software.
software on it. And do we own the copyright to that software?
Yes.
We do. And have we registered that copyright?
Yes.
But we don't have a patent yet. So how do we protect our black box architecture? With?
NDA.
See how easy that is?
Now you just need
Good
Mr.
job.
Or
Wonderful.
hologram would have been.
Yeah, now we're ready to go to Mr. Wonderful. So this group right here, we could spend $100 and form an Idaho LLC. We can call it Thwack LLC. $100. We could have you be the CEO and Alex could be the general counsel. And all we stand up a website called Thwack. We file a provisional patent application that literally takes 48 hours to do it. Literally. So in 48 hours, FreeWix website, right? We stand up Thwack. We don't have to sell any product or do anything. We file a provisional patent application, Thwack, your patent pending mouse solution. Take the trap to the mouse. Superscript TM, common law trademark, bada bing. We start to engage with manufacturers, all of whom sign contracts. We have a black box on the LiDAR-enabled mousetrap that chases them around and using the patent pending technology. And we make $10 million.
We make cheese.
Make cheese.
Make
Who
cheese.
did this?
Great.
Get the
Cheddar.
Yeah.
Cheddar.
Cheddar.
Yeah.
Well, there's a finance company, right? I think
Yeah,
that got
there is
Cheddar,
now.
which is a great. But Cheddar's a great trademark for a mouse too. Shane's our marketing guy. All right. Well, I think we have two. Is that amazing? 2 minutes left for questions. All right. What do you got?
This is hilarious, by the way, because the agency actually uses the mousetrap as a training exercise for people that are learning about patent.
Oh, really? A better mousetrap?
Essentially, yeah.
That's awesome.
So there you go.
Okay. All right. Any questions for our group?
What are the limitations of having a service offering available online and it pertains to like tech support for existing brands like Apple and Microsoft and other technologies? So you're developing tech training for existing products. What leeway do you have, any, to reference those products?
Well, if it's Disney, they will sue you.
Right.
If it's Pixar, they will sue you.
Right.
If it's Apple, they will sue you. But you can create some defenses to that. Okay? There's a very technical trademark doctrine that Alex will tell you about when you call her for a free initial consultation called the nominative fair use defense, that says that you can use a third-party trademark to describe their own product. So that's why you can on your used car lot you can put "we sell Ford cars." It's called the nominative fair use defense. But they can still sue you, of course, right? So as long as you're not committing trademark infringement, patent infringement, copyright infringement, breach of contract, or misappropriation of trade secret, you can do that business, sure. As long as you don't do any of those 5 things.
That's full circle with the Shark Tank comment, because that's pretty much what Mark Cuban did and how he made his money initially, was install software and teach people how to use that software on their computers.
So if you stood up a website and you said, I sell Apple computers and I service Apple products, I don't know, whatever. Okay, Apple sends you a cease and desist letter.
Right.
Alex will write them back on Holland and Hart letterhead and say, this is clearly defensible on the nominative fair use doctrine. If you sue my client, we'll aggressively defend it. And not only that, we'll seek attorney's fees in this exceptional case. Sincerely, Holland and Hart. And I would actually say the same thing over Holly Troxel letterhead, but you see the point, right? That's literally what we would say, yeah? I mean, that's what it is. It's the nominative, it is the
I think she
nominative fair
might
use
sound
defense.
nicer in her letter.
Yeah.
Maybe she wouldn't go, because that's kind of my
The
thing.
2 times I met her today.
Yeah. Jillian, we gotta hurry because we're almost out of time.
So does having patent insurance raise your patent portfolio valuation?
What do you mean by patent insurance?
Like insurance after it is like granted to go after companies that are going to try and infringe on it.
someone's trying to sell you insurance, you're probably getting defrauded. The patent itself is your insurance, so that gives you the ability to go after anybody that's, the whole purpose of the patent is to prevent others from making, using, or selling your product. So that documented by itself is the legal monopoly that you're obtaining there.
Okay.
So
don't
it's
buy
a,
legal insurance.
it's a good point. So just to give you an idea of the power of patents, takes 3 years to get one, and yeah, they're a little expensive. If you get what's called a full-blown non-provisional utility patent, yeah, they're a little expensive. But think of the hammer. For 20 years, from the date you filed the application, you're the only one in the United States that can make, use, sell, offer for sale, or import the patented article. And to sue somebody for infringement and win, you have a patent with 20 claims, 20 allowed claims. Okay, how many of the allowed claims do they have to infringe for you to win? 20? 1, just 1. Huge hammer. I love issued patents. But then again, you never have to sue a single person. Just go out and license them, like Alex said, and retire to Belize or wherever. Sir, I have last question.
All right, so I'm a serial entrepreneur and I just moved to Boise, I'm starting my next business. I have a ton of code and IP from my previous businesses. Not all of it's relevant today for me, but there is some IP that I want to transfer over to my new entity. Is there a way to do that? And is there tax implications of doing that?
Yes and yes.
Okay,
It's
so
the
IP
first
transfer-
one is just contract law.
So do I just buy it from
You
myself?
just have, yes, the answer is yes. You just
Okay.
have the owner entity sign a piece of paper transferring it to the new one, and then before you do that, you check with Alex or your CPA and say, what are the tax implications of my doing this? Because yes, there has to be consideration supporting the transfer, right? And there may be tax consequences. Jonathan, you think that there are tax consequences in that deal, intercompany transfer of IP?
I think you could structure it in a way that there wouldn't be.
Jonathan wasn't busy enough in law school, so when he went to law school and passed the patent bar, he also got a master's of accountancy degree, just FYI. So I look to him for my tax questions. So what do you think?
You could do it. There are ways that you could set it up that you wouldn't realize any sort of gain.
There you go.
But get with your CPA.
Okay, I think we're officially out of time. Last question, last call, as we say. Last question, yes, sir.
So, you guys mentioned initial consultations, just getting the ball rolling. What would be the first step to make sure I'm talking to the right people? Like, I don't want to run around, spend a day explaining my idea and then them being like, oh, that's not really my area.
I mean, Alex, what's your intake procedure? They just send you an email or call you directly, or what's your
Yeah.
Holland Hard intake procedure?
Either, you can call me, you can send me an email, and basic questions, and I can kind of filter out who's going to be helpful to you without wasting your time.
And that's the same for me. So email me or call me, and I'll either send you to Jonathan or one of our patent guys or whatever the case may be. So intake process is pretty simple, just a phone call or an email. And I'm sure that Dave would love to visit with anybody here, since he has real world experience, right? I mean, Alex and I are lawyers, but he has real world experience. And then there's your government guy right there who knows everything there is to know about USPTO.
$3.99 government side of things. But most attorneys, almost all of them, not an ego thing, but they all have bios in what their expertise are. So you can look that up. And if they're doing patent stuff, they have to be registered with our agency. So you can look that up to make sure they're validated.
All right, thanks everybody. Have a great weekend.